welcome to everyone. I'm glad you're turning up at quite a significant webinar for CEDR and hopefully the field in the long run. The reason for this webinar was partly so we can talk through some of the wider aspects of ESG, but also because we're reaching the culmination of a project that started with business human rights, moved into environment and ESG issues, and has led to us to develop a mechanism, the CEDR Independent Accountability Mechanism, or ESG Resolve for short, which is focused on using the developments that have taken place in terms of business attitudes to corporate social responsibility, and those attitudes evolving into broader and deeper commitment to stakeholder attention, at least, and also dialogue for more responsible business conduct. So we have, using our experience of 30 years in working with mediation and other techniques, to make sure this mechanism will assist NGOs, citizens, employees, communities, be able to address conflicts, concerns, grievances in a more effective way in terms of negotiated dialogue particularly, but certainly getting an independent body to have a roundtable approach to ensuring that problems that come up in these areas are addressed effectively and using the best of dispute resolution and conflict prevention techniques. So how we're doing the panel tonight, we're very fortunate having a good illustrious range of speakers. We're doing it in chunks of 3. You'll have seen there were 8 names down, but we're doing it in chunks of 3 on 3 separate topics. The first one on business human rights, the second on conflict prevention, environment, and different techniques for managing collaboratively major projects. And the third one will be spending a bit more time on the CEDR mechanism that we hope will be adopted quite widely over the coming months and years. So let me welcome my first 3 panel members. Rees is going to start us off. Caroline's president and co-founder of Shift, an organization that has been very involved, as Caroline has personally, with the founding of the UN Guiding Principles on Business and Human Rights. And she'll speak about the UNGP and their impact and current thinking around development of UNGP. Robert McCorquodale is a barrister and mediator and also a distinguished former academic, headed up the British Institute of International and Comparative Law, has recently been appointed by the UN Human Rights Council to the UN Working Group on Business and Human Rights. And he'll talk more about the regulatory hard and soft aspects of intervention in these kind of cases. And finally, last but not least, Dan Leader, a partner in Leigh, a well-known claimant firm who's been up to the highest levels of the court system in terms of representing human rights claimants. But Dan's also had experience of in some of these major cases with mediation and how that works through for communities and for different kinds of settlements and remedies in the courts. So Dan will be talking on those kind of areas. So without further ado, let me ask Caroline to kick us off this evening.
Karl, thanks so much, and it's a delight to be with you. I'm excited to hear from the other speakers, and indeed just take a few moments perhaps to reflect on the discussion of remedy and the place of mediation and dialogue in the context of the UN Guiding Principles on Business and Human Rights. Some in your audience may be very familiar with the UN Guiding Principles, others less so, but they're built around 3 pillars. The first of which speaks to the duty of states, actually, with regard to the protection of human rights, including against abuses by business. The second pillar speaks to the responsibility of companies themselves to respect human rights, a proactive expectation to prevent and address impacts on people's human rights that are connected to their business. And then thirdly, the whole of the third pillar is about access to remedy and engages the duties of states as well as the responsibilities of business and other organizations in looking at what needs to happen and what needs to be in place when actual harms do occur. And that third pillar is very, very clear that the central foundation for remedy always needs to be a strong judicial system, right, that can provide an avenue for effective remedy. But it equally recognizes that in no society and with regard to no issue is judicial remedy the unique avenue, and indeed that it should be part of an ecosystem, the foundation for an ecosystem of avenues for remedy, not least for lesser issues that don't necessarily warrant judicial recourse. And for every issue that really needs to find its way into the court, there can be hundreds or thousands of others, of course, that can find their way and find effective remedy through other means as well. So it's this ecosystem thinking that is really fundamental to the propositions around remedy in the guiding principles, non-judicial approaches alongside judicial, non-state-based alongside state-based. And of course, we're used to thinking about this already in the broad business and human rights space when we think about things like consumer complaints, right, where a company would expect to have an avenue for consumers to raise issues directly to see if they can be resolved directly. But also one would expect there to be administrative mechanisms under consumer protection laws and so forth, again, around labor issues, having both internal mechanisms within companies, but also, for instance, in the UK, ACAS, supporting mediation, having labour tribunals and so forth. So this is the ecosystem then within which we think about this. The second pillar of the guiding principles, that responsibility to respect human rights of companies, speaks to a couple of really important elements here. And the first is the need to be prepared for the eventuality where impacts do occur. And of course, everybody wants to prevent those things from happening, and there's a lot in the guiding principles that speak to that. But we also know the realities we work in, and frankly, for any company, they're working in complex environments, not just the largest companies, complex value chains, different kinds of contractual relationships with different entities. They don't control all of the variables that are happening around them in the world. And with the best will, there should be an expectation of scenarios where things can go wrong. And the worst time to try and work out the avenues and the means through which to find a way towards putting them right is when you're in the middle of the crisis. The time to do that is well in advance, to put the processes in place, to be deliberate about that. Think about not just your own avenues or grievance mechanisms, which are part of what's expected, but to think about that ecosystem. Think about what else needs to be in the mix. And that second component the guiding principles speak to throughout, through prevention as well as remedy, is the importance of direct dialogue with affected stakeholders and their representatives. As part of assessing and understanding what the impacts could be or might be, how they're experienced, whether the things a company is doing to address them are working or are not working. So all of that prevention side, but then again, when things do occur, that there's space for dialogue in addressing them. And so mediation, Karl, to your point, is really such a natural and necessary fit within this ecosystem, that dialogue-based form of dispute resolution, something to be anticipated and designed in wherever possible, to thinking very deliberately about how to approach these issues. And I'll finally just say that one thing that we heard a lot as we were developing the guiding principles and talking about remedy and different avenues for remedy and the importance of judicial mechanisms alongside others was a concern that mediation as a sort of a non-public dialogue-based process could end up being a place where the weaker complainants, that the communities, the workers and others in these disputes could be sort of strong-armed into responses or accepting outcomes that were inappropriate, that took advantage of their lesser strength perhaps or power in these dynamics. And of course, any system can be abused. One can have good and bad courts and good and bad forms of any form of remedial mechanism or avenue. But of course, what's so important here is actually mediation done properly, and mediation as the true meaning of the sense of it as a process. And what we saw was that done well, done appropriately, it can have an extraordinarily leveling effect, an empowering effect, ensuring that both sides are adequately informed and supported, not constrained to trying to frame what complainants are bringing in a way that finds a hook in the law, but truly framing it in the way in which it's experienced, not limited in the kinds of remedy permitted or imagined to what's possible within a legal context, but indeed what really feels like remedy to those affected. So offering the opportunities for voice and agency, and even, you know, where relationship matters, for the potential to restore or build the basis for restoring relationship as well. So really, I think we've long seen the need for that more deliberate, prepared and proactive approach to dialogue-based forms of dispute resolution as part of this ecosystem. And Karl's super excited to hear about what CEDR has been working through and developing to bring those opportunities to this arena.
Caroline, thank you very much. That was a really great introduction, a very brief, a very complex topic, the UNGP, when it gets down to the wording. I really like the question of you saying it has to be done properly, because I think that's right. Mediation, and people don't appreciate that, as a really good leveling effect in terms of negotiation power if it's done well and with the right kind of mediator and institution. So again, that's a theme we hope to build on. Let's move next to Robert McCorquodale.
Thank you very much, Karl. And for me, it's a real pleasure to be here and talking about this, because as you know, Caroline, Dan, you and I have been discussing the possibility of this mechanism for many years. And so it's fabulous that it's now launched and deserves to be used widely. Caroline has set out the vital importance of the UNGPs, though she actually underplays her own role in it, where she was a key player. Now, the UNGPs were a catalyst for incredible change in just 11 years since they came into being. As someone who's worked in this field for about 30 years, I can attest what a change it's been. Indeed, in my new role now as a member of the UN Working Group on Business and Human Rights, I can state very clearly that no longer do governments or key business associations deny that companies have responsibilities in relation to their human rights impact, which they used to. Now, that is a very significant change. While the UNGPs is not binding law on companies, it has led to significant change, particularly by national legislation. For example, in the last few years alone, the volume of national legislation aiming for the accountability of business for their human rights environmental impacts, wherever they're occurring, has increased dramatically. This includes broad-based legislation in France with its Duty of Vigilance Act, in Germany with its Supply Chains Due Diligence Act, and Norway with its Transparency Act. There are also specific legislation in Australia, Netherlands, and the UK on matters such as modern slavery and child labour, as well as regulatory actions in countries as diverse as the US and Sierra Leone. And these are all legally binding on many companies. Further, just this year, the European Commission released its draft Corporate Sustainability Due Diligence Directive, which would apply to both companies domiciled in the EU and, importantly, companies domiciled elsewhere, but selling goods and services within the EU. And in each of these pieces of legislation, the need for companies to conduct what's called human rights due diligence is at its core, being a requirement under legislation for companies to undertake a human rights impact assessment of the risk of adverse human rights impacts on communities, workers, and others affected by them. As part of this, there's also a need for consultation with all stakeholders, more dialogue, to use Caroline's word, which is crucial, as well as the possibility of remediation, implementation, tracking, and communication. And in all of this, the ability to try to enable those affected to have dialogue. And that can be an operational grievance mechanism, or can be to bring claims. And these pieces of legislation are beginning to enable that, and they're not voluntary. And therefore, mediation is at the core to assist in this dialogue to help companies to comply with the legislation. At the international level, this is also going on. There are now multiple regulations, including the important OECD guidelines on multinational enterprises, of which Karl has been involved as an important mediator in this process. Excuse me. There's also a clear acknowledgement that a core way forward in dealing with many of these matters, which of course are transboundary, is the use of mediation. The UN Working Group on Business and Human Rights, of which I'm a member, and other UN bodies do recommend mediation as an effective means to resolve disputes in this area, on the basis that it, and I quote, the use of dialogue as the means of addressing and resolving grievances include best practices from mediation. I want to add just one other aspect. Although we have both been speaking of business and human rights, this actually forms a key part of ESG. Why? Because business and human rights is the core aspect of the sadly often forgotten S part of ESG, covering all aspects of social impacts of business. Also, today, the environment is also part of business and human rights impacts. And in addition, some of the new legislation, including the European Community's Corporate Sustainability Due Diligence Directive, refers specifically to directors' duties. And of course, better corporate governance is part of the rationale for business and human rights legislation. So business and human rights has an impact and an influence across all areas of ESG. As well as all this legislation and regulation, there's been considerable litigation, as Dan, who's a key litigator and innovator in all this, will now discuss, including where courts have made direct reference to the UNGPs. So what I've hopefully have covered is how the UNGPs have led to significant change with direct legally binding impacts on companies, and mediation can form an important part of that dialogue towards access to remedy, but also an earlier dialogue in consultation with stakeholders affected. Thanks, Karl.
Thanks very much, Robert. Again, really helpful background for those who need to know more about human rights, developing regulation and legislation. I think it emphasizes Caroline's point about ecosystems, that actually in most ecosystems you find species dependent on each other. And I think what your presentation brought forward quite strongly to me was actually regulation, litigation, and mediation are in many ways useful, complementary systems that to make the whole ecosystem work for the appropriate cases. So that's again a really helpful sense of guidance and direction for developing this field. Finally, last but not least, Dan Leader.
Thank you, Karl. It's a huge pleasure to be with you all today to discuss this important topic and to be sharing the virtual platform with such experienced speakers who all have very distinct perspectives on this important issue. I just want to touch on 3 points in my remarks. Firstly, I'm going to outline the fast developing legal landscape, which Robert referred to, on business and human rights around the world, but particularly in the UK. Secondly, I'm going to make some comments about what I think the direction of travel is for this kind of litigation, including the potential scope for supply chain litigation. And then thirdly, I'm going to explain why I think this initiative is an important one if properly conceived and utilized. So firstly, on the legal landscape, it's fair to say that the rise of international human rights and environmental litigation against multinational companies is now a global phenomenon. The world of corporate accountability has radically changed from where we were 20 years ago. Just in the last few years, to give a few examples, the Supreme Court of Canada has ruled that corporations can be liable for breaches of customary international law in the case of Nevson. In 2021, the Dutch Court of Appeal ruled against Shell's parent company in favor of Nigerian communities who had been impacted by decades of oil pollution, and ordered the parent company, at that time domiciled in the Netherlands, to change its practices. Again, in 2021, the French Supreme Court ruled that the French cement company Lafarge could be indicted for complicity in war crimes in Syria. And in the last 3 years, the UK Supreme Court has ruled unanimously now on 2 occasions in landmark judgments on favor of African communities in large-scale environmental claims against two large multinational companies, Vedanta and Shell. In tandem with all this, as Robert has referred to, we are seeing around the world, particularly in Europe, the emergence of mandatory human rights due diligence laws, which for the first time place legal obligations on parent companies to ensure their subsidiaries and their supply chains are free of human rights and environmental abuses. And whilst for the moment, the UK is lagging behind on human rights due diligence statutory laws, the common law framework has created one of the most progressive legal regimes in the world, and that in turn is having ripple effects in other jurisdictions, particularly common law jurisdictions. There's equally a growing community of lawyers from around the world who are bringing these cases and increasing collaboration between lawyers and activists in the global north and the global south. So, like it or not, I'm afraid multinational companies do face increasing reputational and litigation risk on their human rights and environmental conduct. And it's clear that hiding behind complex corporate structures is no longer going to work. We bring in Leigh and in the UK, cases are brought using standard tort law and the concept of parent company liability. I won't go into the details, I don't have time, but suffice it to say that in the two Supreme Court cases that have been decided in recent years, the Supreme Court actually significantly broadened the scope of potential parent company liability and made it clear that multinationals could be liable, not just if they exercise operational control of their subsidiaries, but equally by virtue of their global policy frameworks, and importantly, if a multinational commits to certain human rights and environmental standards and commitments, but fails to honor those commitments. In fact, and this has been the subject of quite considerable academic writing, but also legal commentary from numerous sources, the potential liability of the Supreme Court is so broadly stated, there's no reason why it could not extend to the supply chain and the value chain. And in fact, we've already seen last year in the case of Begum and Moran, the Court of Appeal has extended liability for ship owners for selling their ships to notoriously unsafe shipyards in the Asian subcontinent. The fact that they've sold the ships and the practices, the unsafe practices, are nothing to do with them is no defense. And as I speak, we have new cases that are now being litigated in the English courts, one against BAT for child labor, alleged child labor in their supply chain in Africa, and again against Dyson, again for alleged forced labor in their Malaysian factories, again in their supply chain. Not in their factories, I should add, but within their supply chain. So the message from the courts is clear. All this has very significant implications for multinational companies who are, as I say, increasingly facing serious litigation risk if they turn a blind eye to human rights and environmental abuses within their group and supply chain. How does ADR help? Well, it may surprise some members of the audience, who I've done battle with, I think, in the past, that I actually take no pleasure in suing multinational companies. My pleasure and the purpose the international work at Leigh exists is to secure remedy for victims of serious human rights and environmental abuses. As a result, in fact, I would say in the region of about 70% of our cases eventually settle through some form of mediation process. That's actually the way it currently works. And the way mediation takes place is through the use of mediators who are generally retired former judges, very experienced QCs, and those litigators generally have very little experience of the broader business and human rights issues and the UNGPs, the other soft law mechanisms which surround this entire debate. Increasingly, though, we are finding that multinational companies are seeking to mediate at an early stage and are cooperating in trying to find creative solutions which offer remedy not only to the victims who are trying to access remedy, but also tries to tackle the underlying issues which have given rise to the tensions and the problems in the first place. Components of these settlements increasingly involve community projects and the creation of independent operational grievance mechanisms so that there can be confidence on all sides that like cases will be dealt with well and independently in the future without recourse to the courts. But the lack of specialized business and human rights experience within the mediation team's CV, as it were, makes it difficult often to find common ground in these negotiations. It cannot be the role of lead A to be solely informing the parties of what international best practice is, and that often is the case. So I welcome this initiative for three reasons. Firstly, I think it will enable companies to tackle human rights and environmental issues head on before they become entrenched in litigation. Secondly, I feel it would help companies to understand international best practice better, not just approaching potential disputes in terms of legal strategy, but also in terms of what is actually the right thing to do in terms of international best practice. And thirdly, I think with the right expertise in the room, it could help find creative solutions to long-standing disputes, which would be in the interests of all sides. The biggest issue from a victim perspective is that they need to feel listened to. An effort needs to be made to understand and engage in good faith with their concerns, as opposed to being met with high-handed legal tactics. Nothing will enrage and energize victims more and galvanize their efforts to fight for justice than a high-handed strategic response from a multinational company. If this mediation process helps in engendering a greater level of dialogue and finding creative solutions to long-standing problems, then I predict there will be a very high demand for its services. Thank you.
Dan, thanks very much, and thanks, by the way, for what turned out to be a great plug as well, but no doubt based on bitter experience with litigation, which we often come across as mediators with clients on both sides of the cases, as you kind of highlighting. So well done also all three for keeping to time. I'm going to take advantage of that and not ask you any further questions at the moment. Hopefully we'll get back to something later, but let's move to our next chunk of discussion around this whole topic of ESG and the next three panel members. Thank you very much, Caroline and Dan and Robert. So we're about to spotlight our next three panel members who are picking up different topics, although Sarah Ellington, who will introduce first, a partner in Watson Farley Williams, I know reputedly has acted on some of the corporate cases that Dan was referring to in the past up to the Supreme Court. But some of her more recent interest is on conflict prevention techniques, collaborative working and work with major projects. So no doubt hear more on that. Ralf Lindbäck is a senior in-house lawyer, principal lawyer in a major Finnish company, Wärtsilä, with a heavy emphasis on renewables and sustainability. It specializes in power engineering and marine engineering. And Ralph's also involved in the risk management side of the company. So no doubt that will reflect on ESG questions of risk as well. And he'll give us an in-house counsel view as well as how companies can step up in the new environment. And finally, Chris Bellringer is an associate in the disputes team at Freshfields, specializing in areas like engineering, procurement and construction. but also involved with the environment group and environment cases. So he'll also touch on his work in those areas too in relation to the mechanism. So let's start with Sarah. If you can kick us off, Sarah, please.
Thanks, Karl. So I think to start off, I just wanted to reflect slightly on the kind of title of the webinar and ESG as a whole, because it's a term that's obviously used a lot, but certainly not one that anyone can particularly agree on. Neither can people agree on what all of the elements that fit under it are, nor what the approach to each of the elements should be, or who should be responsible for them. And so I think that we need to approach all of these questions with the thing in mind that there's no single approach to these issues, and also that ESG issues arise in lots of different contexts. I know that we often think about them in terms of the end impacts, and that's obviously a very important area, but there's also conflict in relation to ESG issues within corporates themselves, between company employees and board members, between different levels within multinational organizations, and with investors as well. So I think that we need to bear that in mind when we're thinking about mediation and how we can use that as well. And as you mentioned, Karl, I'm no stranger to using mediation once disputes have arisen. I am a dispute resolution lawyer and have been litigating on these issues in the English courts, as well as through other mechanisms, including the OECD specific instance mechanism, which itself builds in mediation as a core part of the offering. And has long incorporated a number of these different types of mechanisms and elements of remedy, which Dan spoke about there. Also, I think we've seen mediation being used more, or a form of mediation, to keep contractual relationships on track. Things like dispute resolution boards and standing neutrals. For a long time, these were really used more in the Nordics, a little bit more in the US, and definitely in the kind of realm of construction contracts and technology contracts. But I think that those concepts are now bleeding through into other areas. They've often been used where there's this kind of imbalance between the supplier and the customer, for example, that imbalance of power. And I know that a lot of people would see that kind of power imbalance in a lot of the end impacts in a human rights sense as well. And also what I think is significant here is that those types of standing neutral, mediator, coach type roles that have been used to resolve issues within contracts as they go along and to keep them on track, have been used also in multi-state contracts as well, where there are all these kind of competing interests and other things going on behind the scenes, which is often the case in these types of issues as well. It's never kind of one stakeholder and another. It's always a multitude of different things that need to be taken into account. So we've also seen mediation there, and we've also seen, to a limited extent, although perhaps not talked about so much, mediation used in this kind of preemptive remedy sense, which is what we've been talking a bit about recently, Karl, in terms of not getting to the dispute stage, where actually, things have been going on for a while. Each of the parties have really lost trust in each other. Other parties have had to come in order to represent interests, and that kind of erodes the trust further. But thinking about how we can actually, at the outset of a relationship, kind of set that on the right course. And I think, we're undergoing a transition here as a society, as a global society. And perhaps the starkest thing there is the energy transition and what we need to do as a global society in order to make that happen. And that requires a lot of resources that need to be dug up from the ground. in a lot of different countries, which actually can be a real opportunity. Because there's a lot of developing countries that are very resource rich, and a lot of people that would like to benefit from the employment and other opportunities that comes from that, and the infrastructure that's built around it. But we know that when we get these types of projects, there are going to be impacts that arise. And this kind of idea of preemptive remedy and using mediation style techniques, even if it's not a formal mediation, but thinking about this kind of ecosystem approach that Caroline talks about, where we've got this need for balance of the different interests, essentially that's what a mediator does. They come in, they listen to the different interests and they create a balance. So, I think that here there is this opportunity to use mediation in a number of different ways, informally, perhaps more formally, if things need to be escalated past a certain point. And because we've got this history that we know that it works for kind of once a dispute has arisen, and we can use it in the preemptive sense, but we can also use it as a kind of point of escalation where some of the operational grievance mechanisms that might have been in place haven't necessarily worked to the fore. And I said at the beginning that these kind of disputes or differences in relation to ESG issues happen at all levels. I think we can think about preemptive remedy not only in terms of these kind of big projects where there's community impacts, but also in the more kind of corporate and investor sense. And we're definitely seeing a rise as well in impact investment at the moment, and this need to kind of protect the mission of the company. And that means that there are also going to be potential ESG conflicts between investors or investor companies that have been invested in to try and safeguard that mission. So there's another area where we can kind of have this mediator coaching standing neutral position potentially drafted into the contractual terms as someone to really kind of help bring the relationship along. And so, we've got all of these different uses of mediation. Great that it's such a flexible tool. And it's just about finding the right places for it to kind of slot in within that picture. And it doesn't only need to be one or the other. It can definitely kind of be each of those things as they go through.
Thanks very much, Sarah. I'm glad you highlighted particularly actually it's often forgotten that ESG is not just about the corporate responsibilities, but there are lots of investor and investment funds out there now who are very alive to questions of the risk of their investments if they get some of these issues like human rights wrong, and quite apart from feeling social responsibility for doing these kinds of things right. And I think investment funds are now looking at the whole question of how to manage their investments in relation to social responsibilities as well as just the financial responsibilities, which is driving up attention to techniques and governance that actually works to improve responsibility. Which brings me to Ralf and experience in the corporate side in power and maritime engineering, etc. Ralf.
Well, first of all, thank you very much for having the opportunity to be here. I'm really pleased to sit here in this panel with all of these prominent colleagues of ours. I will use a short introduction. I'm coming from the corporate world, how international cooperation addresses these subject matters. I will divide my short presentation introduction into three parts. First of all, a few words about the framework or frameworks. And second, a bit more about governance. And finally, then look into enforcement issues. So the corporate angle, the in-house counsel view starts with, of course, the applicable law, and already mentioned, we have the UN guiding principles on business and human rights mentioned here. The OECD guidelines on multinational enterprises was mentioned as well, soft law. We also have this proposal for a directive of the European Parliament and of the Council, EU Council on the Corporate Sustainability Due Diligence, which is there in front of us. Now, for those who want to do a deep dive into that proposal, I strongly recommend Caroline's white paper from Shift on the subject matter, which identifies the discrepancies in the existing OECD guidelines, the UN guiding principles, and the one now suggested by EU in a marvelous way. That's something which you can download from the web. So we have that on the top as a corporation. Then we have, of course, national legislation where we operate. So that's the regulatory framework which we have in front of us. I will not stay there longer than that. I'll jump to the next one. I mentioned the standards. Now, the corporation is committed to sustainability, and we do want to report it properly, of course, in our annual reports. Here we run into the issue that there are so many different standards available. We have actually, as a corporation, then chosen the Global Reporting Initiative, GRI, which is a fairly widely used standard globally. It's by the Global Sustainability Standards Board, GSSB, but there are others. I mean, in US, you have the SASB, the standard provided by the Sustainability Accounting Standards Board. And then there are few ones to come. IFRS is looking into sustainability disclosure standards as well. So here we have multiple standards in front of us, which is not really perfect. But the key takeaway here is that all of these, if you are going for reporting on ESG, requires that the company should disclose management processes and procedures, including concepts and tools, which identify, assess, prevent, and mitigate existing and potential adverse material topics that impact its business value chain, including supplier and customer relationships. That's the common thread in all of these standards, reporting standards. So there we are. So that's what we have in front of us when we are committed to sustainability and do want to report it. So now let me then, with a few words, drill into the governance part. It starts from the top. The corporation has a vision and mission, but above all, a purpose for its existence. It has a sustainability strategy, ESG strategy, which has targets, clear targets, and outlines management systems, is very precise on two topics: responsible business conduct, read OECD, for instance, requirements. Also, supply chain management. It does have these systems, the management systems and processes in place. The corporation reports it in accordance with the standards, GRI standards, in its annual reports. And on top of that, there's a continuous stakeholder dialogue ongoing. That fits perfectly into my day-to-day work, responsible for claims and dispute management in the corporation. Why? Because we do have in that function a way of working process which identifies and encourages early proactive resolution of issues in dispute as they arise. And we try to efficiently mitigate existing and potential adverse impacts on a company's business value chain, and thereby we can say that the legal function in the company is very well aligned with the corporate vision, mission, and purpose, the sustainability strategy, as it then contributes to a sustainable development and responsible business conduct in its claims and disputes management process. It's structured, it's consistent, and it's based upon collaborative, way of collaborative working with parties, and it aims to transform issues into interest-based solutions and opportunities, very close to what is the outcome from mediation as well. Time and cost spent on administrative case management is reduced. Risks which may disrupt the company's own activities or business operations, including supply and subcontracting chains, become controlled and mitigated. And it's based the process improves stakeholder and business relationships indeed. The way we engage with conflicts are key in creating long-term value. I'll leave it at that stage. I'm happy to discuss more details, but now I'll wrap up by a few words about enforcement. So how do we really look upon ESG related conflicts or disputes? The answer is very simple. Arbitration is not the most favorable, or litigation. In these cases, we are indeed very much in favor of EDR. And from that perspective, remediation processes and grievance mechanism, as now introduced by CEDR, is very welcome indeed. The question is now how to get the message across to the markets and the industry. Remains to be seen, but I think that all stars aligned that this will become something like Chatham House rules or something very famous, which is now has started and it looks very promising. I think I wrap up by saying that how will this develop? Unfortunately, as Dan here mentioned, you need to understand the type of conflicts here. I think I would like to say that these type of conflicts is very much value chain driven, value driven, which brings it closer to the sort of board of directors and the value, corporate value, in contrast to sort of standard claims and disputes and litigations, which are extremely operative. It goes into, it's on a different level, and therefore also the dispute resolution mechanism should be different, very collaborative. So we need to make sure that the board is also on board and they know exactly how to address issues in dispute when it comes to ESG. I'll stop there and looking forward to questions and discussion later on. Thank you very much.
Yeah, thank you, Ralf, for the insights on the in-house lawyer's perspective as well, and quite a wide range of issues, and the intriguing suggestion that we should be matching the Chatham House rules in our ambitions for the mechanism. Thank you for that. Over to Chris.
Thank you very much, Karl. I would just to start echo what everyone else has said about how it's a pleasure to speak to you all today. I'm going to just say a very few words on environmental claims, in particular, how that fits into the mediation landscape and some of the factors we find relevant to think about when mediating environmental claims. I think when Karl sort of talks about this topic and this being an ESG discussion, it sort of militates towards thinking about environment as the E and then the human rights issues as the S. But I mean, increasingly, I think we see the distinction between environmental and human rights claims is falling away. And claims that, I mean, private practice lawyers would traditionally think of as historically environmental law claims are bringing in human rights principles, and so extensively referencing things like the UNGPs that Dan and Caroline and others have discussed. And in reality, this trend is probably only likely to continue as emerging supply chain due diligence legislation, the likes of which Robert's touched on, is going to require companies to take due diligence steps and in some instances address human rights and environmental impacts in their own operations and in their supply chains. And so I think this all means that the points that have been previously made, and in particular by Dan, about mediation in the human rights space are of equal relevance to environmental claims. But as you think about environmental claims, there are still some points of differentiation, I think, between environmental claims and human rights claims. And I was planning to touch on a couple of those that we see in our practice, and then also discuss some of the points that we found important to get right when trying to successfully resolve those environmental disputes. So on the first topic I was just mentioned there, the unique features of environmental claims, I think the first that we typically see is that environmental claims tend to involve issues, be it a buildup of waste or a leak of a material, that have occurred over a long period of time. That can differ from human rights issues that often, although not always, relate to a single or a series of impacts. And this element of environmental claims can bring with it a much more complicated factual picture with more parties involved, be it successive landowners, other parties who have used the land, different tenants, and then an array of third parties like technical advisors, project consultants. That complex factual picture is something that needs to be thought about when thinking about how to resolve claims like this. The second point, I think, which goes in the same direction, is that environmental claims can often require significant technical expertise to resolve, with questions of whether, at least in English law terms, a duty is owed, turning on detailed evidence on the standards of knowledge at the relevant time, questions of whether there's been a breach requiring expert evidence on the standards of performance and operation, and then also questions of causation requiring complex analysis of dispersion modeling and such. So what does this mean for mediating environmental claims? This can lead to a perception that environmental claims are more challenging to resolve through mediation. However, I think in our experience, those challenges are by no means insurmountable, and there are a number of issues that we have found important to get right when trying to resolve these claims through negotiation and discussion. The first of those actually really goes to one of the points that actually Dan mentioned, that is ensuring that when you are starting a mediation of an environmental claim, you have the right people and the right communities in the room, but at the same time, without it becoming unwieldy and jeopardizing the potential of a successful conclusion. It's completely key that the right communities are there and that the representatives have the right authority, but then equally, from, as you see from the company side, there's a real focus on having clarity on who's participating and maintaining structure so that it's easier to find that common ground. But that, of course, can't be at the expense of excluding people and excluding communities who rightly feel they should participate and would like to put their case to the companies that they perceive as responsible for the damage suffered. The second issue I was going to touch on is the importance of trying to ensure mediation avoids a focus on the technical scientific evidence and issues of liability that I mentioned earlier. Given the nature of much of the scientific evidence in play in these claims, it can be very difficult to bridge the gap between the respective positions through negotiation. There just isn't a middle ground that one can cross. And so instead, mediations where both sides really take a step back and consider how a complainant's grievance can be addressed in a way that's realistic and doesn't open up other liability risks for the company, have the best prospects of success. And thinking about some of the examples we've seen a diverse range of ways of resolving environmental claims. Dan has touched on some of them, but in the context of the supply chain disputes that Dan mentioned, we've seen disputes resolved at a very early stage by the company agreeing to steps like adjusting its supply chain due diligence program. And these are the sorts of remedies that I think companies are increasingly willing to consider, but it does require an open mind on both sides of any mediation to make something like that succeed. I see I've been plunged into darkness. Let me move and get some light. The final point I was going to make is that our experience in these types of disputes, mediation often works best when it takes account of what we would think of as the local level engagements, but it's really the sort of the universe of engagements that Caroline touched on earlier. And there might already, in a lot of instances, be forms of communication and engagement taking place between a company and the complainants in question. And that's particularly the case for some of the disputes you see in the environmental space, which focus on mines and forms of energy infrastructure that have these types of community engagement or sort of community level grievance mechanisms set up. These routes can be, we found, very, very helpful for lawyers on both sides in trying to resolve these disputes at an early stage, and sometimes even more successful than sort of structured formal mediation in London. And that approach actually really echoes with some of the points I know I've been speaking to Karl about in the context of this mechanism, which is really focused on local level culture and custom being reflected in the approach to mediation. So those were just a few points I was going to mention on the environmental claims, but I think the real takeaway is that when it's approached with a focus on the local context and a willingness to be creative, early mediation in these environmental claims, it can be a very effective way of avoiding time-consuming and technical litigation.
Chris, thanks very much. That's a nice reminder of one of the strengths of mediation is its ability to deal with nuances, I think, more than the court sometimes. So that was a good insight in environmental claims and how often there are, as you say, factual and cultural nuances that would need to be addressed for any intervention to be effective. So thank you, all three. We're now we've been asked the question specifically, how will the independent accountability mechanism work? And that's coming up in the next session of the panel. So thank you, Sarah, Ralf, and Chris for now. And let's move on to the final session, the final module of our evening. And joining me are Jennifer Egsgard, who's a Canadian attorney mediator who specialised in human rights work, and who joined the CEDR project at a very early stage 2 years ago, working with me in a diverse range of consultation interviews with international NGOs and investment institutions and law firms to develop our approach, and also gave a great contribution in terms of developing our documentation. And Eve Pienaar is another mediator for CEDR and has been an in-house lawyer in professional bodies and in due diligence and specialist certification agencies. So Eve has also joined recently as a consultant on the ESG project for CEDR, and we'll talk a bit further about how we see the accountability mechanism assisting with risk management and building up going forward. But let's start, and I'll obviously contribute in this session as well. So let's start with Jennifer. Over.
Sure, thank you, Karl. I will echo what everyone else has said, that it's really a pleasure to be here. As Karl mentioned, a large part of what I did while consulting with CEDR was consulting with a lot of stakeholders, including many of our speakers today. And it really was such a pleasure, as you can imagine, having heard the level of their expertise and experience that they have to share. So I just wanted to talk a little bit about the consultations that we did and some of the sort of bigger themes that came out of that haven't already been touched on. A lot of it has been addressed already. And then I will very briefly outline what the structure of the mechanism is that we've developed today. And as Karl, I think, will speak to, it's still sort of out for consultation at the moment. During the course of our consultations, we talked to 43 lawyers working in different aspects of the ESG space, from the more regulatory side to those engaged directly as claimant or defendant counsel on business and human rights issues, as we've heard from today. Several financial institutions, in-house counsel, and representatives of corporations who deal directly with business and human rights and ESG issues on the non-legal side. Several offices of the UN Principle for Responsible Investment, a number of NGOs, including Accountability Council, the Global Reporting Initiative, and the Business and Human Rights Resource Center, number of consultant organizations that advise in this space, including the Business for Social Responsibility, Article 1, and the Shareholders Association for Responsible Enterprise, several industry associations, including in the oil and gas and mining sectors, and several investment agencies as well. I would say overall, echoing what you've heard already from the speakers today, the feedback we received for the need, in terms of the need for this type of mechanism, was extremely positive, with most respondents seeing a real need for the mechanism. The legal and reputational risks, as we've heard, particularly from Robert and Dan in the ESG area, are growing so quickly, including due to the onset of new legislation, that the area is very complex, and the corporates are happy to have a way to identify and resolve ESG related problems early, taking them off a litigation track. And the mechanism can also, as we heard, be a useful way to meet demands to consult and collaborate and provide a structured and respected mechanism for so doing. From the NGO side, we heard that often there's just not a way for communities to appropriately speak with companies, and in that lack of ability to communicate can lead to greater problems and indeed greater harm. And the ability to provide this kind of mechanism can provide greater voice to communities, which hopefully can allow, as Chris just referenced, the ability to facilitate creative resolution and maybe quite easy resolution that can prevent harm in the future. A number of consultations did also point to the need, and this was touched on today, but not addressed so much, for this type of facility to be used in the investment world, particularly for large institutional and other investors who employ enormous amounts of capital, both in private and public companies. And many are now turning their minds to how to meet obligations in the ESG and business and human rights space. But there's sometimes a disconnect between what their goals are and then the what's happening in the companies in which they invest. So several NGOs working in this space suggested, as I think was just mentioned today as well, that there can be a place for ADR to take place, or a mediated, facilitated dialogue to take place between investment institutions and civil society as relates to problems with the companies in which they're investing. And similarly, the financial institutions we spoke with also are grappling with, well, how do we lend great sums of money to projects and ensure that that money does not become engaged in either environmental or social harm. And they too also are working in a number of avenues in this area, but we're excited by the idea of having a facility where this type of early communication could help avert future harm in those types of projects, that they could direct the organizations to which they're lending money to and say, here is one way in which you can help avert harm and increase communication. One thing that came out one thing we really thought a lot about in this consultation is whether or not this facility ought to have an adjudicative element as well as this agreed resolution element. And there were some, from the corporate side, the positive aspect of adjudication is that it would provide finality in a dispute, or that would be the good thing if it did. And then there were questions about whether it actually would, and could it be challenged and that sort of thing, a decision. For the NGOs, the positive aspect of a firm decision at the end of this was often sort of around accountability. And I think we decided at this stage that it's better to focus on the agreed resolution avenue rather than adjudication, partly because it's really what CEDR's strength is and what CEDR is known for. But also it allows CEDR to build up this expertise. And there was a real concern that the adjudicative element might also cause parties on both sides to not want to sign on, that they might worry that their rights would be curtailed in some way by signing on to this, if it were included in adjudicative harm. So I think for the plan for now, and Karl can correct me if I'm wrong, but I think is to launch this as a facility seeking agreed resolution, and then in several years, take another look at whether adding an adjudicative arm would be useful. We were also asked about, well, how would this differ from, for example, the national contact point, or operational level grievance mechanisms. And I love Carolyn's description of this space as being an ecosystem. So obviously this would be one part of that ecosystem. The national contact points, and also in Canada here, we have the Canadian Ombudsperson for Responsible Enterprise that's also seeking to bring mediation in as a way to resolve disputes between Canadian companies and affected communities. And I think the idea of the CEDR mechanism is that it would complement these options. It would be more widely available. Some of the national contact point or the Canadian Ombudsperson obviously are restricted to particular geographic areas and sometimes to particular topics. The CEDR mechanism would also be independent from governments or corporates, whereas the national contact point sometimes can be seen as a little bit too government connected, and the OGMs can be seen as a bit too close to corporates, whether or not that's accurate, but that can be their perception. The CEDR mechanism would also offer really professional, experienced mediators to facilitate these discussions with a view towards the resolution in practical fashion. And of course, the NCP often does have very experienced dispute resolution professionals, but that's not always the case depending on the particular office. And the OGMs also can vary in their use of professionals. So hopefully there'd be like a standard of expertise in the mediators that were being used. Yes, so those were some of the major things that came up. I wanted to, there were more issues too, and some of which I will address in my review of how the mechanism will work. And I know that Eve and Karl will speak to some of the other issues that came up as well. So in terms of a broad overview of how CEDR is thinking of how this is working, we'll I'll address these in sort of a number of headings. One is who may lodge a request for resolution of a complaint. So the idea would be that individuals, community groups, small businesses, or their representatives, who would most likely be lawyers or NGOs operating in the appropriate arena, could bring a complaint under the mechanism if they reasonably believe that they or relevant stakeholders have been or could in the future be adversely affected by environmental and or social impacts and or governance decisions caused by the relevant business. I'm not going to read everything. I'm just giving you the gist of it. And I think that the actual draft may be circulated at a later time for comment. The request for resolution of complaints can be only submitted in the following circumstances. One, if the parties agree, so really a consent-based resolution setup. Also, two, where a contract or ADR clause or industry association policy requirement refers such disputes for resolution to the mechanism. So again, that requires the consent of the respondent company at some point in time, where the respondent subscribes to the mechanism in response to a court order, judicial recommendation, or regulator decision. And so those are the major ways in which the mechanism would be able to take jurisdiction of a complaint. And then how to lodge a complaint, the complainant would, in writing, submit a number of details in respect of the complaint to CEDR. The respondent would have a chance to reply. CEDR would make an eligibility determination on the complaint. So a complaint would not be accepted if it was anonymous, if it was not in the parameters of the mechanism, if it was frivolous, vexatious, or fraudulent, and in several other circumstances. And so the idea there, one of the concerns we heard is that this would a floodgates issue, that if a company signed on to this, that they would suddenly be dealing with, so many complaints that became overwhelming. So one idea is that to have this eligibility stage, it would allow through the complaints that were meaningful and necessary to deal with. After determining eligibility, and both sides would have the chance to make submissions on it, CEDR would have an administrator at CEDR would do a triage and determine which was the best procedure to deal with the complaint, whether it's mediation, conciliation, facilitation, or other ADR approaches, and the parties would have a chance to weigh in on this as well. And then the parties could select a mediator, or if failing their ability to do so, CEDR would appoint a mediator.
Jennifer, I've got to stop you there because I know
that was basically it. Thank you, Karl. I was pretty much done. Thank you.
There will be some circulation of the rules in due course, but I think you've sketched the main question of parameters on our search for corporate and industry association buy-in or subscription. One of the key things I'd just add to what Jennifer said was the one of the things the mechanism will be opening up in a much bigger way than previous mediation is the range of ADR techniques will be widened because of the complexity of some of the ESG issues that Chris was particularly referring to in terms of facilitated discussions or mutual evaluation rather than mediation of joint fact-finding as a prelude to having a serious negotiation. But that, I think, brings together the kind of whole focus of this is creating a flexible but sophisticated mechanism. And Jennifer's been a big part of building those kind of those various clauses she was referring to. So I'm going to pause there because I'm keen to have Eve talk about the role going forward as well for the mechanism. So over to you, Eve.
Thank you, Karl. And of course, I echo everybody else's comments about being very excited to be part of this wonderful new project. So yes, I'm Eve Pienaar. So I've been mediating commercial and workplace disputes for 15 years now. And my mediation practice covers a broad range of sectors from professional negligence and property and construction, etc. But I also draw on my experience of working with CEDX, which is a platform business providing insight into the ESG standards of their supply chains for buying organizations. The SMETA standard, which is what CEDX stands for, and has rolled out for the last 18 years, remains a highly regarded methodology for protecting labour rights across all sectors internationally. It's not the only standard, but it's certainly one of the standards against which supply chain due diligence is being regulated at the moment increasingly. Companies are facing an ever-increasing burden, as we've heard, and therefore scrutiny over their ESG credentials, TCFD disclosures, modern slavery reporting, national legislation. I think we've mentioned the Norwegian Transparency Act, the French laws, the proposed 2022 EU Due Diligence Directive will all provide a legal framework against which claims are anticipated, alongside, of course, the positive impact of businesses operating with more respect for ESG stakeholders and their workers. For many organisations, adopting an independent, neutral third-party process aligned with the principles of natural justice may be a commercially sustainable solution. And this is, in part, Wärtsilä's independent accountability mechanism plays an important role. Because the mechanism is voluntary in nature, promoting mediation and other ADR solutions and collaborative values, it will, I believe, be an added attraction as it mitigates against the risks of litigation. It's not just, as we've heard, time and cost which can be saved, but also managing the risk of emerging jurisprudence and the uncertainty this entails. As mediator, I never cease to be impressed by the creativity of solutions which parties involved in mediation often find are able to deploy when they come together in the legally privileged mediation space. Finally, I think it is worth pointing out, as Jennifer mentioned, that for the moment, the mechanism rules do not go so far as to provide an adjudicated outcome if mediated negotiations fail to reach settlement, but that may be something which we can build on in time. Keeping the mechanism to a confidential, voluntary and consensual process, I think, affords a measure of control and security for the parties who engage with it, and on which we may continue to build. But I'm going to stop there, Karl, because I'm mindful of time, and I know that you would like to say some words, and we'll probably have some questions.
Yeah, thanks, Steve. No, just to maybe emphasize a personal point for me is I had very much got into this field through business human rights work and the OECD NCP system, as was mentioned earlier, and just doing the whole range of rich cases around environment, due diligence, community care. One of the things that struck me very early on when I first started doing these kinds of cases was that there had been no dialogue between the parties, generally NGOs and major corporates that are covered by the NCP system. It just struck me they were missing such an opportunity of not having that dialogue. And that's why I began to investigate, can we promote mediation more in these kinds of cases? But I think particularly this, when Jennifer and I were working on the early stages, it became clear that mediation as such was perhaps too broad a process description. And what the field most needed was some kind of recognized structural mechanism, which could be accessed and engaged as a very credible, independent sounding board for convening these kind of situations, for making sure there's an effective dialogue or other kind of ADR intervention quite early on. On adjudication, just Jennifer asked me the question. Yes, it's still an option if two parties agree to the mechanism and want a final resolution, then we will either produce rules that will cover that, or we'll do it for an industry association that wants finality as part of these kinds of cases. So the key message I want to leave about the mechanism is it's intended to be really flexible. This is a field where, as we've heard time and again, there's a need for a variety of ecosystems. There's a need for flexibility and responsiveness to parties and cases and sectors. And we really intend to make the mechanism kind of work to that particular dynamic or melody in order for it to be really increasingly used and accessible to a wide range of parties. And I often look at even government actions and think, why haven't you used some kind of independent accountability process to get to a better understanding of the issues that you're facing and what you're trying to deal with in policy terms, and the kind of reaction you'll face from the electorate if you go ahead with some of these decisions. And similarly, companies can be well informed on the same basis. So I'm going to pause there and bring the rest of the panel into the frame. If there are any questions, one of the questions I've just, let me just check. Yeah, there's a question about the kind of mediators that would be appropriate for this mechanism, and some of you touched on that. I know Dan is used to working with ex-members of the judiciary, amongst others, senior QCs. But I think everyone in this area tends to recognize that there's a real value in working with mediators who are aware of the local context, either cultural, language, technical, or even legal context can sometimes be very relevant to the risks the parties are facing. So I don't know whether any of the panel want to add to that in terms of what will make this work well, culturally, in terms of what CEDR needs to do to create the kind of infrastructure of mediator talent and capability to make it work well. Can I have a couple of volunteers on that one? Yes, Jennifer.
I think one thing we talked about a lot in order to do just that is the use of co-mediation. So finding an expert and respected mediator from a local community or from a local context who could work with a mediator that might have more of the commercial skills that the parties think are needed from CEDR. So just the use of co-mediation to bring in different expertise as well as cultural expertise.
And Ralf, do you use fins prominently or go wider than that for international cases?
Yes, we are very culturally sensitive, so for sure we will look into these kind of aspects where we are getting the local content into the framework as well is extremely important. But I think. If I may add on this topic, I think it's now extremely important that, for instance, the GRI standards have addressed also these type of mechanisms and what they require a company to report on these type of mechanisms in case they have set up their own or if they are then subscribing to a certain type of grievance mechanisms. So I would just like to flag that probably CEDR has done it already to benchmark it against these type of standards now coming up. IFRS I already mentioned, but the GRI as well, which address grievance mechanisms and set up certain requirements in that regards, and from there to make sure that the CEDR concepts fits perfectly into it is crucial in order to get the buy-in from the industry and the markets. I don't know if probably that has been on the agenda already, but
no, so
GRI is fairly detailed in this regard in their standards when it comes to these mechanisms.
And another important question that came up in the chat was the question of how to decide the voice of a community. So I suppose looking at some of those who've been involved in community litigation and mediation, particularly in the human rights arena, I suppose, as well as environment, how do you best go about addressing those kinds of questions in relation to dispute resolution? Dan or Chris, do you want to, or Robert?
Well, I mean, the practice that we engage in is we're often approached directly by communities, and they, on the whole, have a leadership structure which is often recognised by the government and the local government. So, for example, I'm representing a range of communities in the Niger Delta, and they all have a legal structure to them, and we are directly instructed by the leader of that community and the Council of Chiefs. But we're also very clear that we need to consult widely and hold regular public meetings so that everyone in the community knows what's going on. Mm-hmm. In addition, you're not just representing a community, you're often representing individuals in tandem to the community. So individuals who've suffered harm, either environmental or human rights or occupational health, So they will have their own individual claim, which is distinct from that of the community. And that can run, it depends on the case, but it can run from 50, 60, all the way to 30,000. Depends on what we're talking about.
Caroline, you've got your hand up.
Yeah, I think just to add to that, that in a number of cases, we've seen the importance of there being space for affected groups, communities to actually organize their own voice, and just recognizing that there often are not ready-made structures within which that happens, and that a successful process needs to recognize and create that space for that to happen with the requisite support, so that they can come to the table in an organized way that represents what they want to collectively bring, and how they can do that most effectively. So I think that's an important part of the process in many contexts where they affected groups don't come from a pre-existing structure that already enables them to articulate their position those ways.
And I think thinking like that has led to, that's why the drafting of the mechanism puts probably a lot more emphasis on the classic entry to ADR in terms of an eligibility phase and a triage phase, where it will mean CEDR will have more opportunity to kind of just get to grips with the dynamics of what's being presented as a problem issue. Sometimes it will be very straightforward, like a late litigation mediation, for example, but particularly early in emerging disputes or emergency stakeholder issues, very often, as Chris was referring to, there are a whole raft of complexities that need to be thought about as part of ensuring that a good dialogue can take place with the right people at the table and the right information for them to be working with. I remember that from an early slide, and when we started the mediation training, actually one of the early slides was mediation is about getting the right people to the table, having the right kind of conversation, with the right kind of potential outcomes available to the parties. So it's a very pragmatic, but at the same time purpose-driven approach to making sure that dialogue works when it's working under independent auspices. And the courts have a similar challenge in jurisdictional terms, as I saw recently in a recent mediation. Someone was asked the question about to what extent on a practical level do you need to commence legal proceedings in order for some of these processes to be really effective. I mean, my personal view is it does depend on the dynamics of the case, the kind of sectoral, cultural context, but I know those who've been claimant lawyers have probably got strong views that you need to show you're serious sometimes for corporations to sit up and pay attention. Dan's nodding, so you know, if you want to add anything to that, Dan, but you've probably had, you know, months or years of testing that out sometimes. On the other hand, I think the strength of mediation, it does kind of, and that's why sometimes managers resist it, even if it's in their dispute escalation procedures and contracts, that going before someone independent to have your spat with another company or another manager does make you sit up and treat the situation differently. So that's why I think mediation does have a leveling the field effect, which is really helpful, particularly where you do have claimants who are perhaps underrepresented or not so well represented. The role of financial institutions, another question that came up. We have, Jennifer and I, and we have spoken to a number of financial institutions in the course of developing this, and there is a lot of interest in risk management aspects of this kind of mechanism for financial, healthy financial reasons as well as social reasons. Most of the major public bodies, this is another question that arose, was how currently are groups like IFC handling ESG disputes. And most of the bodies like IFC, World Bank, EBRD, now have their own independent accountability mechanisms, obviously publicly funded. And for projects they're investing in and they're already dealing with, they're all quite careful now about making sure there are internal grievance mechanisms to make sure they are overseeing these projects and intervening in an effective way if there are community or public complaints. And so what the CEDR mechanism is doing is not replacing those, but hopefully complementing them, building on the experience around accountability mechanisms, but making it available right across the private sector or the public sector that doesn't have existing accountability mechanisms. Again, the CEDR mechanism would be available. So we're coming close to time, so I just want to give, if anyone wants to make a final comment from the panel for this evening before I close. No. If not, it only remains for me to say, well, first of all, thank you for the CEDR team for setting up the logistics of this and managing it. Particular thanks to what I'm sure most people listening to this will have agreed is an excellent panel and diverse but great range of voices and topics for this evening. I know we've not done justice to quite a few of the topics, but this was meant as a taster session, but also a recognition that the mechanism has lots of places to go here. And we do hope for those of the audience who are still here, please get in touch. We will be in touch with you afterwards in terms of following up with questions, but do get in touch with CEDR as well if you want to find out more about the mechanism or have suggestions for areas that we could be working in that are hot to trot, so to speak. We'd love to hear from you. And again, many thanks to the panel. Lovely to see lots of familiar faces too in there. As you'll have gathered, lots of the panel have been working with CEDR on these kind of developments for a couple of years now. So great to see familiar faces and to see things coming to fruition after many discussions. So thanks for joining in, everyone. Lovely to see you or hear from you, and we look forward to future developments going forward.